Hello and welcome to the May 2022 episode of My PIP Monthly. My name is Amber Rouse Holloway and I'm a partner here at our Troy office. For our May 2022 topics, we have, of course, a case law update, the case of Price v. Austin, and this is a published or will be a published opinion, and then we have Kimberly Johnson v. Geico Indemnity Company, and this one was issued May 12, 2022, and is an unpublished opinion. And then lastly, we have trending topics in PIP litigation, and for this portion, I'll talk about reasonably necessary and efficacy, and how to attempt to get cases disposed of with this type of argument that the treatment was not effective and therefore not reasonable nor necessary. Alrighty, first up we have the published opinion of Price v. Austin. In this case, the Michigan Supreme Court majority found that since there was a possibility that a jury could call into question the credibility of a defendant's testimony, summary disposition should not have been granted. And I'll go on after I give you some background of the case to talk about why this is going to be difficult moving forward. In Price, the court was presented with the issue of whether defendants failed to present clear, positive, and credible evidence sufficient enough to establish that a defendant experienced a sudden emergency in order to overcome the presumption of negligence arising out of defendant crossing the center line and causing a head-on collision with plaintiff's vehicle. So here we have a case where there was a motor vehicle accident, obviously, and the defendant crossed over the center line of the assuming highway and caused the collision. So because this happened, there was a presumption of negligence and the defendant was alleged to have caused the accident. But here, the defendant is now claiming that there was a sudden emergency, and that's what's in question in the instant matter. But ultimately, the majority found that since there was a possibility that a jury could call into question defendant's testimony and credibility, summary disposition was improper. So I did want to briefly talk about the sudden emergency. So here specifically, the defendant, his name is Samuel Austin, indicated that his sudden emergency was a severe coughing fit that actually caused him to black out. That him blacking out is what caused his vehicle to cross over the center line and strike plaintiff's vehicle. So when obviously plaintiff filed suit, and then defendant proceeded forward with a motion for summary disposition. And in his motion for summary disposition, he presented testimony from himself, multiple treating physicians, the responding police officer, GPS evidence, and the lack of skid marks on the road. Defendant argued that rebutting the presumption meant there was no dispute of material fact, thus entitling him to summary disposition. Plaintiff obviously disagreed that a rebuttal would result in summary disposition, but provided only bare accusations that defendant was lying about having passed out. The trial court granted the summary disposition, finding that plaintiff failed to demonstrate that there was a genuine issue of material fact whether defendant experienced this sudden emergency. Of course, this appeal followed, and ultimately the majority found that when the credibility of a witness or deponent is crucial, summary judgment should not have been granted. So essentially the trial court erred by finding summary disposition in favor of defendant, and that the jury should be allowed to determine if the witness's credibility, or if they believe the witness at all. So here the jury would have had to determine whether they believe the plaintiff, that defendant was lying, or whether they believe defendant's story and his credibility that he did indeed black out and there was a sudden emergency. Judge Viviano gave a pretty strong dissent in this issue, so I did want to highlight that. She turned to Michigan's longstanding case law, MCL 257634, Section 1, and she cited that in Michigan, a presumption is merely a procedural device that shifts the burden of producing evidence to the party against whom the presumption operates. That's the case of Meyer v. Leonard. It dissolves when that party presents sufficient evidence, though. So the presumption can be rebutted by showing on the part of the party violating the statute of an adequate excuse under the facts and circumstances of the case. So here, that adequate excuse was the sudden emergency. Judge Viviano also cited that in order to overcome presumptions such as negligence, that you must rely upon the framework set forth in the case of Kirshner v. Duff, which provides that a rebuttal of a presumption may be accomplished on the testimony of defendants alone. If such testimony is clear, positive, uncontradicted, then that is good enough. If said testimony negates an element of plaintiff's prima facie case and plaintiff has not proffered any evidence calling into question defendant's credibility, defendant is entitled to summary disposition. So obviously, Judge Viviano cited some case law which dissents with this opinion here. So this will be interesting going forward. But as of now, the published decision cites that credibility should go to the jury and summary disposition should not be granted. Next up, we have the case of Kimberly Johnson v. Geico Indemnity Company, and this is an unpublished opinion that was issued on May 12, 2022. This case here was remanded for reconsideration in light of the published opinion, Mimic Insurance Company v. Fordson. So previously, the court reversed the trial court order denying defendant summary disposition and remanded for entry of an order granting summary disposition in favor of defendant because there was no factual dispute that plaintiff submitted fraudulent claims for attendant care and replacement services. So this case, by way of background, it was a 2017 automobile accident in which plaintiff had injuries, after which she claimed she could not perform several household tasks and also some personal care or attendant care. Her former boyfriend, his name was William, and her son, Jacob, performed those duties for her in light of her alleged injuries. Her minor daughter also assisted her with the attendant care, specifically the bathing and the dressing. Plaintiff thereafter, of course, submitted the claim to defendant, Geico, for replacement services and attendant care, and then defendant refused to pay, and plaintiff filed suit. Ultimately, defendant moved for summary disposition, arguing that the plaintiff's insurance policy was void under the fraud provision because plaintiff made claims for her replacement services and attendant care, while plaintiff was in Ohio and Florida without her caregivers, specifically without her boyfriend and her son, but not without her daughter. The trial court denied defendant's motion, relying on the Bari v. IDS Property Casualty Insurance Company case. Talked about this case in detail, but the Court of Appeals determined on appeal that there was no genuine issue of material fact that plaintiff misrepresented her need for replacement services while she was out of state and submitted fraudulent claims. The COA reached the same conclusion regarding plaintiff's claims for attendant care while she was out of state as well. So the attendant care was provided by her daughter, and even though her daughter was with her, those claims, the Court of Appeals came to the same conclusion that those claims were submitted fraudulently as well. Now, again, this case was remanded due to the Fordson opinion. And due to Fordson, the court concluded that defendant could not void the contract entirely, but it was not obligated to pay PIP benefits for claims that were clearly fraudulent. And here, plaintiff was likely making claims for medicals, replacement services, and attendant care. So basically what they're saying is the Geico was not entitled or did not have to pay the attendant care and replacement services, but may have to pay medicals in the future. But so essentially the entire policy was not void, just these fraudulent claims or claims that could be proven fraudulent. Ultimately, the trial court's order denying defendant's motion for summary disposition was vacated, and the case was remanded to the trial court for reconsideration consistent with this opinion. So essentially saying that, nope, we can't void this policy, but defendant is not required to pay for these fraudulent claims. So she can still go forward receiving medical claims, medical mileage, and things of that nature, but not necessarily these fraudulent claims. And it'll also be interesting to see the trial court's order regarding future claims for attendant care and future claims for replacement services, because here it's saying that only the claims that were clearly fraudulent. So it doesn't say that she can't receive it in the future, just these past claims, but it appears as if the majority of her case represented attendant care and replacement services. That's the site listed for the Fortson case, which I do want to talk about briefly. In Fortson, the misrepresentation at issue were also fraudulent intended care claims submitted by the claimant's parents, who are the named insureds on the policy. The insurers sought to use those misrepresentations as a basis to rescind the policy due to the anti-fraud provision. The Supreme Court explained that the insurer could not have relied on those misrepresentations when it agreed to insure the Fortson. So at the initial inception of the policy, there were no misrepresentations yet, and that there was no argument showing that the misrepresentations in the case constituted a failure to perform a substantial part of the contract. In short, in the Fortson case, MEMIC's contract-based fraud fails because it was not the type of common law fraud that would allow for rescissions. It's important to note that in the Fortson decision, it was a situation in which fraud was alleged to have committed by the policyholders, but the claimant was not a policyholder. So it's an innocent bystander issue. All right, moving on to trending topics and PIP litigation. Here again, I wanted to talk about the efficacy of treatment and how to possibly get claims or cases dismissed if it can be proven that the treatment was not effective. So as we all know, pursuant to MCL 500-3107, Section 1, personal protection insurance benefits are payable for the following: allowable expenses consisting of reasonable charges incurred for reasonably necessary products, services, and accommodations for an injured person's care, recovery, or rehabilitation. Moving on, a treatment or procedure that has not been shown to be efficacious can neither be reasonable nor necessary under the No Fault Act, and that's from the case of Crone v. Homeowners Insurance. I have this cite in the slides if you guys need it. What happens here is you may get a case and you notice that the treatment is some type of new treatment that you've never heard of, that the provider is trying out on the specific claimant or plaintiff, and it's something that you've never heard of, and there's no studies to prove that it is a normal course of treatment for that specific injury. For example, a plaintiff that has, again, this is an example, a plaintiff that chipped their tooth or broke their tooth due to a motor vehicle accident, but is now being prescribed water therapy by their physician or their treating physician. Those two obviously have nothing to do with each other, but you may find instances where the plaintiff is trying to get reimbursed for that water therapy treatment. So here, once you file this type of motion saying it's not effective, the treatment is not effective, a provider may try to rely on studies. I've seen providers get letters of medical necessity from that treating provider indicating how basically it's medically necessary that the plaintiff undergo this type of treatment for this amount of time, and it's specific to that treatment, that they will see a benefit from that type of treatment. That's normally what those letters of medical necessity look like. Again, this can be done before a filing of a motion as well, sometimes in the beginning of discovery or before it even gets to defense counsel. The adjusters may recognize that, this is strange, ask for proof of efficacy. And so when trying to prove that the treatment they're trying to claim benefits for is effective, they may offer an expert's opinion. And then in defense of that, you must look to MCL 600-2955, Section 1, which requires that a court determine whether an expert's opinion is reliable and will assist a trier of fact by examining the opinion and its basis using these factors: whether the opinion and basis has subject to scientific testing and replication, whether the opinion and its basis have been subjected to peer review publication, and the existence and maintenance of a generally accepted standard governing the application or interpretation of a methodology or technique. And lastly, the known or potential error rate of the opinion and its basis. So these are some pretty strict factors, but when you're talking about medical treatment, these are very common things for most medical treatment. So it should be somewhat of a red herring when a type of treatment can't qualify based on or an expert and their opinion about that type of treatment can't qualify the methodology based on these subsections of MCL 600-2955. I'm sorry, here goes finishing them up. The degree to which the scientific community accept it, and whether the basis for the opinion is reliable and whether experts would rely upon it again. And lastly, whether the opinion or methodology is relied upon by experts outside of the context of litigation. So it can't just be you have experts, in this case, agreeing that this is a reasonably necessary and effective treatment. It must be a generally accepted viewpoint from the scientific community that it is acceptable and effective for that type of treatment. And also, you may find situations like water therapy, for example, which when it first started did not meet these qualifications, but now it does for certain things. But like I said, it may not qualify as reasonably necessary for a broken tooth or TMJ for that, for example. Or you may see, I know a lot of it is with like psychotherapy or claimants that are claiming injuries to their head or, traumatic brain injuries, those type of injuries. A lot of the treatment that people are finding may not meet these qualifications. And that is all I have for you today. Again, thank you for attending my PIP Monthly. As always, if you have any questions or concerns or would like to discuss any of the topics here today in greater detail, please feel free to call me at the number listed below. Feel free to email me as well. Thank you so much.